Now we're going to move on to geopolitics and NFTs, the legislative maneuvering in the US, UK, and EU. It's another 25-minute panel, and I'd like to introduce Judie Rinearson, Zhang, Mihaela, Apostol, and Matthew van Buskirk. Please welcome our speakers.
Hello. Welcome to NFT London. I've had a wonderful time at NFT New York and just arrived from New York yesterday. We're going to do a very quick introduction, and then we're going to dive into the realities of the geopolitical approach to how NFTs are regulated across our regions. I'm Judie Rinearson. I'm a partner at K&L Gates. It's a big law firm with offices in London and New York and LA and Hong Kong and Australia and Germany, anyway. And I am one of the co-leaders of the Digital Asset Blockchain Group. I was one of the lucky people who testified in front of New York State's hearings on how to regulate crypto back in 2012, and that's ended up giving us that wonderful piece of legislation called bit licensing, I regret to say. I've been in this space, and this is the growing part of my practice, and I want to introduce our other speakers. First, Mihaela Apostol, Zhang, and Matthew Buskirk.
Thank you, Judy. I'm Mihaela Apostol. I'm a UK lawyer and Romanian lawyer working in dispute resolution for the last 9 years, especially in international arbitration. And along with a couple of colleagues of mine, we set up a discussion forum called ArbTech. It's a discussion forum on dispute resolution and technology. And we encourage conversation between tech people and people coming from the legal world.
Hi, my name is Zhang. Good morning, everyone. I'm a colleague of Judie's. I'm at the London office of K&L Gates. I'm on the regulatory team, and my main focus is on the fintech, which covers payments, e-money, and crypto.
And I'm Matt van Buskirk. I'm co-founder and co-CEO of Hummingbird RegTech. I'm a former regulator in the US. I was the first head of compliance at Circle, and happy to be here today.
So what I'm starting out with, what our plan is, I'm going to talk a little bit about what the risks are of NFT, especially from the perspective of regulators. And then each of our panelists are going to take the view from their geopolitical location. Mihaela's going to talk about EU, Kai's going to talk about UK, and Matthew's going to talk about the US. So what is it about NFTs, which seem like really nice, benign products that have finally given digital artists a way to get compensated, musicians use them, companies use them for branding purposes. What is it about them that makes regulators nervous? Why does this essentially benign product have to be so highly regulated? Well, there's a couple of reasons. First of all, at least in the US, there's a perspective that it's just a scam, and that there's that people are being taken advantage of, and there are definitely, let's face it, some evidence of market manipulation and those kinds of things. So they're worried about scams, they're worried about phishing hacks, they're worried about insider trading, money laundering, and just bad investments by gullible consumers. I think that's the biggest thing they're worried about. And so much of that can be addressed by disclosures, by transparency, all those things that a good, well-run organization would endorse. But until that happens, until there are, at least from the US perspective, because it's such a litigious place, until there are like really clear laws, there's a sense that this is really very dangerous. Just 2 weeks ago, 4 states halted the sale of metaverse NFTs on the Slotty site that was a casino metaverse, because they thought that that was selling unregistered securities and was misleading investors. So they are watching, the US regulators in particular. I'm based in the New York office. They're watching this very carefully. They're also, again, worried about scams, things like, and apparently OpenSeas has just announced that they're going to be piloting a system to freeze trading if they see anything that looks suspicious. I don't know much more about that, but we know that this is on the radar screen, not only of regulators, but also the industry. So now I'm going to turn this over to my colleagues. I'm going to ask Mihaela first to talk about the EU and what their approach is.
Well, the EU has been quite active in this area, trying to take measures to regulate crypto assets. Let's just talk them broadly. So at the moment, there are a couple of regulations in force which do not necessarily use the word non-fungible tokens or NFTs, but that does not necessarily mean that those regulations do not apply to NFTs. So if you do not find non-fungible tokens in a directive or regulation, just don't put it aside and say, oh, it's fine, it doesn't apply. It's not the case. So I just give one simple example of the anti-money laundering directive, which has regulation covering people or legal entities who are trading or are intermediaries of art. So as most of us know, NFT is used as a form of art. So if you are trading art up to a certain value, so it's not like 10 pounds, but if it has a significant value, then the anti-money laundering applies, and that comes with a lot of burdens and requirements to keep track of your transaction, to identify your clients, and so on. So this is an example of a directive that is enforced, and it's applicable without necessarily using the term NFT. Another important piece of legislation about which everyone is talking about, and the previous panel mentioned it before, is the MiCA legislation. It's an abbreviation for Market in Crypto Assets. And this legislation is close to be final. It's been drafted and redrafted, and NFTs has been put in, taken out. But the latest version that I consulted is from 10 of October, so it's quite recent. And from what I've seen, the version is close to final, so we expect that by the end of the year or beginning of next year, we're going to have a final text from the European Parliament. And why this is important for NFTs? Well, the directive qualifies the crypto asset in the following. They say it's an asset which has a value. So basically, it could be anything. Well, of course, this asset, if this asset is traded or stored on a distributed ledger platform. So NFT for sure fall into this category. And then you read the preamble to see under which conditions. So it says that if the NFT is unique and non-fungible, then it does not fall into the regulation. And if you read this, you say, oh, everything is fine, but actually the next paragraph comes with further condition that makes things a bit different, which say the following: if the NFT is part of a collection, that rings a bell, right? Then the regulation is applicable. So if you launch a collection of more than one thing, it's not enough for the NFT to be unique from a technical point of view and have a unique identifier. It needs to have something more than that, a unique right, a unique asset, underlying asset. So do not assume that it does not apply to NFT. It actually does. And what does it mean? What's the impact, right? We have found out it's applicable. Why is the impact? Well, the impact is the following. Everyone who's trained the NFTs, who have a platform, who store the NFTs, and they work, they are either based in EU or offer this service to EU consumers, they will have a lot of things and paperwork to do. And one of them is to prepare a white paper before starting the business. And this implies to explain what are the business. They need to put some funds aside in case the business goes wrong, so more money. They need to have in place regulations for complaints. They need to have in place, they need insurance as well. They need to have in place as well regulation in terms of conflict of interest. I think we all heard about the OpenSea employee who knew about the NFTs that was supposed to be traded on the first page, and then he took advantage of that, bought it in advance, and then made a lot of money. So to avoid this type of situation, the MiCA regulation is trying to eventually protect consumers. But at the same time, will make huge burdensome on the shoulders of those who are traders or intermediaries of NFTs. And the application process is quite lengthy. This is what I will mention. An application could take up to 4 months. So you need to be authorized. You ask the European state where you're based for authorization. They will conduct an assessment. And as I said, it's not necessary to call your NFT unique and non-fungible. They will actually analyze it and see how unique it is. And all this might be seen as a deterrent for creating more NFTs, but at the same time is meant there to protect the overall market. So it's difficult to strike a balance. I'll just conclude to say that you need to keep an eye on what's happening. The regulation is not enforced yet, but it's about to be very soon. And the good thing about it is that whenever they have a final text and adopt it, they will give 18 months for it to be enforced. So that will take us 1.5 years. Approximately, the MiCA regulation should be enforced by 2024. So that gives a bit of time. I will not talk more and give the floor to my colleagues.
Thank you. That's fascinating. And like in the EU, in the UK, right now we don't have a uniform regulatory framework for crypto assets, let alone NFTs. So right now the approach is piecemeal. But before I talk about the UK regulation, I want to mention something from an overall perspective. The previous panel mentioned that the UK government announced that they wanted to make UK a crypto hub, and that seems to be the intention at the government level. But if you watch the FCA keeps putting out notices saying, well, don't do crypto. This is dangerous. This is a scam, so don't do it. So there is kind of a disconnection between the government and the regulator. So that's an overall like a political scenario. And then you come down to the actual regulation of crypto assets. Because right now we have a piecemeal approach. There are at least, I think, 4 concepts of crypto assets. Each is slightly different, but they share many similarities in their wording. So they each function only in relation to their separate regulatory regime. There are existing regimes that are currently enforced, like the money laundering registration for certain crypto assets business. And for that purpose, the definition of crypto asset is wide enough to capture NFT. So if you trade that, if you exchange NFTs, or if you hold NFTs for a client, you may need to register with the FCA under the money laundering regulation. And also, Mihaela has mentioned that under the money laundering directive, the trading of art may need to be registered, because the UK's money laundering regulation is derived from the EU directive before we left. So we have that similar regime. But right now, the work of art is defined in a traditional way. So there is a very detailed definition from HMRC for the VAT purpose. We use that definition for this purpose as well, for the registration purpose as well. So from that definition, right now NFT probably doesn't fall within the definition of works of art. So if you simply trade NFT, you probably don't need to register because you're an art participant or art dealer, but you probably need to register because you are a crypto asset business if you fall within those specific 2 categories. So that's for on the money laundering, the existing law. And there are also reforms and proposals right now going around, and the rules are still yet to be finalized. And there is one concept within the various proposals, called qualifying crypto asset. This definition has a focus on fungibility. So for something to fall within that proposed regime has to be fungible. So NFTs would fall out. But right now that definition is still being discussed because the industry is asking what does it mean, fungibility? And what kind of a condition do you have to meet in order to be fungible for that purpose? So we'll have to see what kind of final definition we will have, and then for the general NFTs, you will need to see whether they could fall within the existing regulatory frameworks. So it all depends on the features and designs of the NFT, whether they could be seen as a security token, an exchange token, a e-money token, or a utility token. If it is a security token, it will be regulated. If it is an e-money token, it will be regulated. But if it is a utility token or an exchange token, generally, the FCA doesn't care too much. But the problem with that is, in the UK, we don't have a uniform, single concept of security. We have this concept of specified investments, which covers a series of specific instruments. So you need to analyze each one to see whether, depending on the design and the features of the NFT, whether that NFT could possibly fall within any one of those categories. So there is no single concept, oh, this is a security. So that brings the cost of compliance. You need to look at each definition. You need to look at the design of your token to make sure they don't fall within the regulatory framework. But right now, we don't have any specific announcements from the regulators that on NFTs only. So it's all about crypto assets, etc. So I'll stop there.
So I'll preface this by saying I think I'm the only person on stage who's not a lawyer. I take a slightly different sort of view on how to think about the risks in this space. It was mentioned on the panel previously that the approach in the US is often regulation by enforcement. So when there's a lack of clarity, a lot of regulatory agencies will just sort of try to make their own clarity by suing people, which we have seen multiple instances of that, and particularly the SEC has had a lot of that going on. The broader NFT ecosystem, I think that tracking the developments of how things are defined and how they're regulated, what they're classified as, is a very important thing to do, and you're going to need good lawyers to stay on top of that. But I think the longer-term strategic perspective to take on this is looking at what the regulators and policymakers care about in this. Are these things being used for any illicit activity? Are there scams happening? The regulator mindset tends to be very risk-focused, obviously, so they're going to see the downsides and not necessarily focus as much on the upsides. I think that it would be beneficial for any company that's trying to launch in this space to be aware of what the negative possible outcomes might be, how people might be abusing what you're trying to build, anticipate that, and then try to proactively take steps to build controls and try to prevent those activities from happening so you can present yourselves positively to the regulators out there. An example of the lack of clarity in the anti-money laundering space, in the US, there's the Department of Justice asked Congress not too long ago for legislative clarity, saying that yes, the NFT ecosystem does fall underneath the anti-money laundering regime to give them the authority to do various things. So I think that taking the long view of this, being aware that people are going to be looking for scenarios where bad actors are taking advantage of this ecosystem and taking advantage of people in the ecosystem. It means that even if there are technical gaps in definitions today that you can kind of classify yourself as one thing and not the other thing to avoid some level of scrutiny, that may not actually be a good approach in the long run, because the regulators you're eventually going to have to deal with may see this as you trying to circumvent their supervision. And if you can instead take an approach saying, we may technically not fall under this definition, but we understand that this is what the policymakers care about, therefore we're going to take these steps to prevent front-running trading, money laundering, whatever it would be, you can buy yourself a lot of goodwill, I think.
Thank you. And we've heard so much about how much uncertainty there is in the regulatory sphere. Historically, emerging businesses like crypto assets and NFTs have avoided regulation, but do you think the time is now changing where we actually need regulation to survive? And if so, what approach do you all think is, and which of your geopolitical locations do you think is going to be taking the lead?
I guess the EU will take the lead, and we already have seen that. The answer...
You've already taken the lead in, in privacy, as well as Mika, I agree.
Yes, and it's necessary. Definitely there's a need for regulation, but what I think it's missing is having people with a tech background being involved in drafting those regulations, because legal people might not understand all the issues and not understand how those products function, how they are created, and their regulation might not serve the purpose. So that's my opinion, to have some people with a tech background participating in this process.
Yeah, I think in the UK, it's going to be regulated sooner or later, and it's just a matter of how. And the FCA, and because of that disconnection I just mentioned, so that probably, I'm guessing here, that probably explains the kind of a slowness in the FCA's approach, in the regulators' approach to the crypto sector. They keep putting out notices, announcements, but without actually consulting on solid proposals in terms of how to regulate this sector. So there is this political uncertainty, and also there is this level of knowledge and expertise, because the regulators, the FCA, wants to understand the sector better before it rushes in the regulation. But given Mika is sort of in place, so I think that can offer some kind of insight into how this should be regulated. And now the FCA is, because of the pressure, I think, from the MPs, from Parliament, from the government, the FCA is increasingly like inserting itself as a gatekeeper to be a regulator that keeps the bad actor outside of the regulated sector. And now the focus is also on consumer duty, the new consumer duty regime. So I think that'll be the kind of regime or framework they will be looking at to see the outcome. If they want to regulate this, they want to see what kind of outcome they want to see that in the sector after the regulation. So that's why there are so many proposals floating around, but we still haven't seen any concrete rules and requirements.
I think the lack of technical knowledge within policymakers is one of the biggest gaps here. But one of the things I've noticed within the congressional staff in the US is that they're really putting a lot of effort in learning this space. And if any of you are operating in the US, I would strongly suggest trying to actually go to Capitol Hill and meet with representatives. There are a number of congresspeople who actually care about this and are interested in learning, and that's the best way we can ensure that the rules end up being actually useful, is if we're not letting it happen in a vacuum.
Hear, hear. Thank you very much, panel.
Thanks very much, guys.